Welcome to Divorce 101. This video is intended to give you a general overview of the typical issues that can develop in a divorce case. If you wish to watch it in its entirety, please stay here with me at this time and we will take you through the subjects one at a time. If you're more particularly interested in a given subject, such as child support or equitable distribution, you can go to the practice area section of the website and watch just the portion of the video related to that particular subject. No matter which of the videos you watch or the other information you gain from our website, you're still going to have questions about your particular circumstances and case. Please call the law firm for Family Law to schedule your free initial consultation to meet with me to discuss the particulars of your situation. Thanks again for visiting our website, and we hope you find this information useful. Our children are always our most important consideration, and they are also the most important consideration to the court in dealing with any family law matter. The concepts of custody, primary residential care, and winning or losing are no longer valid under Florida law. The legislature has recently changed the law to reflect the fact that we want both the parents to be as actively involved in their children's lives as is possible. The concept of primary residential care and secondary residential care has been replaced both with the requirement that we develop a parenting plan that outlines the nature of the decision-making authority that each party will have over various aspects of the children's lives, and that also outlines how the parties intend to co-parent successfully after the completion of their case. A time-sharing agreement is also put in place that specifically outlines the terms and conditions of each parent spending time with their child. No longer is it considered to be an adversarial proceeding. The attorneys and the parties now try to work together to establish a plan that both parents can work with after the dissolution of marriage or the paternity case is completed. At the Law Firm for Family Law, we attempt to work very closely with our clients to develop a parenting plan that will allow them to successfully co-parent their children after the case is completed. If you are now facing the issues that used to be known as child custody, call us, talk with us about the circumstances, and let us show you how we can assist in developing a parenting plan and time-sharing arrangement that will actually work for you in the real world. Child support is required under Florida law, which means that neither parent has the right to waive the other parent's obligation to support their children. The amount of child support that's to be paid by each party is determined by calculating the net monthly incomes of the party and then looking to the statute book to determine the amount that each party is to pay. Frequently, the calculation of the net monthly income is the most complicated and difficult part of determining child support. Once the base amount is established by the statute, daycare costs, medical insurance, and potentially private school tuition can also be factors that are calculated into child support obligations as well. At the Law Firm for Family Law, we have experience in determining the net monthly incomes properly and making sure that the child support amounts for each party are correct. In addition, we also have experience at both the collections and enforcement aspects of child support. So if you're having a problem with determining the initial child support, collecting the child support that's already been awarded, or enforcing the orders of the court, we at the Law Firm for Family Law are in a position to assist you with those problems. After the issues involving our children, the second most important aspect of divorce is usually related to equitable distribution. In Florida, the standard for equitable distribution is that the court is supposed to equitably divide the assets and liabilities of the marriage. There are important issues that can arise in this respect. The first is that while equitable presumes somewhat equal, it does not necessarily require it, and the court can do an inequitable distribution of assets in such instances where it may benefit minor children, such as providing the marital home to the parent who receives custody of the child. Additionally, the issue of what's marital and non-marital arises. If you brought substantial assets into the marriage in the way of a house or a car, cash, or other investments, those assets may not be subject to distribution by the court. It's important before beginning any process of negotiation with your spouse that you fully understand exactly what's a marital asset and exactly what is not a marital asset. At the Law Firm for Family Law, we can assist you in reviewing the entire financial structure of your family to make sure you have the information you need to make intelligent decisions about how you wish to have your assets divided between the parties. The last major issue which develops in many divorce cases is that of alimony. When most people think of alimony, they think of a situation where they're required to write their ex a check every month until the ex either remarries or one of them dies. But there are also several other forms of alimony in the state of Florida: bridge the gap alimony, rehabilitative alimony, and temporary spousal support. Each of these alimony types has a specific application, and one or all of them may be applicable in your particular case. Temporary alimony, for example, spousal support, is the funds that are designed to maintain the status quo during the marriage and to keep the spouse provided for while the divorce is proceeding. Bridge the gap alimony is intended to give the party a fresh start post-divorce so that they can get back on their feet financially. And rehabilitative alimony is specifically designed to allow the spouse to get the specific training or education they may need to be able to go out and support themselves in the real world. At the Law Firm for Family Law, we can assess the particular facts of your case, tell you whether or not you're a candidate or potentially at risk of having to pay alimony, and we can then provide you with an analysis as to which type of alimony may be applicable and what your potential benefits are under that aspect of the case. One of the things that we can count on in life is that there are going to be changes. And when there are changes, sometimes it means that final judgments or other court orders need to be modified. Typically, those changes fall into two major categories. One is financial, and the other is those dealing with children's issues. In the financial area, obviously we're talking about child support or alimony. Changes in your financial condition or in the financial condition of the other party may result in modification in either of these areas. We can sit with you, go through the particular financial circumstances involved in your case, and let you know what it is you're facing in the way of a modification. With regards to children's issues, there are two areas in which modification is predominant. One is in changing primary residential care. As you'll recall from our previous video, statute was recently changed in Florida so that parenting plans and time-sharing agreements have replaced primary residential care and secondary residential care as considerations for the court. As a result, even if you were granted primary residential care originally, post-judgment modification of that will involve the formation of a new parenting plan and a new time-sharing agreement. We can assist you to make sure that the best interest of your minor children are protected at all times and that you receive the best consideration possible from the court with regards to your proposal on what's in the children's best interest. The last major issue we see in the area of modifications is that of relocation of minor children. Florida law is very particular with regards to this subject, and it is important that the statute be followed exactly in order for you to obtain the necessary authorization for you to relocate your children. The statute requires that you either obtain a court order or that you obtain the approval of the other parent if you intend to relocate your children more than 50 miles from their prior residence. At the Law Firm for Family Law, we can assess your particular fact pattern, compare it to the statute requirements, and make sure that you obtain the proper authorization so that if you relocate with your minor children, you're not required to send them back at a later time. Call our office today to discuss this important issue, and we will be glad to be of assistance to you. This concludes our review of the major issues that can develop in a typical divorce case. Please remember that even a small mistake now in an issue such as child support, alimony, or equitable distribution, or time-sharing and parenting plans can result in a lifetime of unnecessary complications. At the Law Firm for Family Law, our mission is to assist you with the changes and challenges that come to your life as a result of having to deal with a family law issue. Please contact us at your convenience to schedule your free initial consultation. We look forward to talking with you. Thank you.